Yeah, maybe they're in the wrong room. You're the only one with us, Mr. Marcinski.
I'm sorry, sir.
I think you're the only attorney with us.
Okay, well, I see.
Ms. Schmeeler's here, but she's the last on the list to take up. If she was first, we could start that up. But
Well, Judge, we might be able to get her out of here.
Getting hold of Joseph Fabre since he seems to be late most of the time.
Judge, in regard to Ms. Schmeeler, the parties did file an agreed order for continuance in the Donaldson matter. The state does not have its evidentiary drug testing back. Filed an order that specifically indicated the state would be taking the speedy trial time. I don't know that that went through, but Bailey and I reviewed it and submitted that last Wednesday.
I don't even, let me, I don't know if she's recording yet, so I'll, she went to see where our attorneys were. You might have to call them, have somebody call them, because if they're just sitting, you might not be looking at their phone. We need Mr. Fabre. Oh, he did? Mm-hmm. Is Mr. Hibbs here?
Yeah, he's on the phone with his attorney, Mr.
All right, can you hear me, Mr. Fabre?
Yes, I can, Judge.
All right, you're the prime case, you're recording, right? Mm-hmm. All right, this is 25 CR 66, State versus Derek Hibbs, here for pretrial conference. This is the prime case for trial next Tuesday. Parties state their appearances, please.
Good morning, Your Honor. Larry Marcinski, County Attorney on behalf of the state of Kansas.
Joseph Fabre appears on behalf of Derek Hibbs, who I understand is present in the courtroom.
Mr. Hibbs, come on forward to the podium if you would. As I said, this is the prime case. Were the parties ready for trial next Tuesday?
So, Judge, Mr. Hibbs has been in and out of mental health facilities, as the court's aware. At the last pretrial we had, he recently was in another mental health stay but got out. But I have spoken to him, and he is interested in resolving this with a plea agreement. And Mr. Marcinski sent me an email about that last week. We've also had previous discussions about how to resolve that. Mr. Hibbs is finally in the place where he's ready to do that. So I think we're going to ask for just maybe like a status setting in a week for Mr. Marcinski now to finalize the details.
It's a very simple case. It's a very simple case, Mr. Fabre, and it's old enough. I've got to move some. It's
That's
very
fine,
simple.
Judge.
It's supposedly an eyewitness officer sees them trespassing. Then there's a car chase. It's fleeing elude. This is as simple as it gets. And so
feel free to set up for trial.
If you want to resolve it today by plea, I'm here. But
no, just set it for trial.
I'm not canceling a jury trial if everybody's ready for trial with the witnesses.
I'm trying to save the court some work. If the court wants to go ahead and set it for trial, we're good with that, and we'll try to work it out.
It's set for trial, and if you want to work it out, that's fine. But I just, my experience is I unset these, particularly these really easy ones. I unset them, and nobody comes to the table and never gets resolved. So
I understand.
Okay, all right. So if you want to resolve it, let me know. We can take the plea up anytime prior to trial. But I'll leave it on and maybe have a backup in case that one sounds like it might be for plea. So
that's good. Thank you.
Does that work for you, Mr. Marcinski?
Sure. I mean, it's difficult to be completely ready for two trials, but I'll call Joe as soon as we get off of this and we'll try to get it ready.
Well, if you want a trial that you can add as easy to get ready for as this one, this is it. So can't be that difficult a flee and elude as long as you have your witnesses available. Okay, moving on to 25 CR 20 State versus Jesse Lamb. Party state appearances, please.
Larry Marchinsky on behalf of the state, sir.
And Mr. Lamb is present in the courtroom and with counsel Jess Hamey by Zoom. I don't see him yet. There he is.
Yeah, Mr. Lamb's here. Well, you've heard the announcement. The first one's going. Sounds like it may be a chance that it goes away. Is this one ready for trial?
I mean, the state's has its witnesses subpoenaed. I believe I'm ready for trial, sir.
I can be ready for trial, Judge.
You can be?
Yes, Judge.
Okay. Why don't we leave that one on to, in case the Hibbs case pleads out, which it sounds like it may. We'll leave it on as well as a backup to the Hibbs case. All right, moving on to 25 CR 123, State versus Will Eaton. Party state appearances, please.
Larry Marchinsky on behalf of the state, Your Honor.
And Mr. Eaton, I believe, is there in the courtroom, right?
Yes, he is. And the first matter here is the motion to withdraw. I've read that.
Judge, that's not the first matter. The first issue for the court, a motion that was filed in November, is a motion to reduce or modify the bail as being excessive.
We did that last week.
No, Judge, that was a motion for furlough so I can get him into treatment. Now I'm asking.
I took both matters up.
So the court's going to leave the bail at $1 million?
Yes. And I even stated the reasons for that at the hearing.
Yes, and that's why I filed that motion a long time ago, because the court's reliance on community safety is an unconstitutional means of determining bail.
And I ruled last week, as you recall.
All right. Well, then we should take up my motion to
That was
withdraw.
the only reason, because if you look at it, what the alleged actions here, he took a gun and went to the road and fired into a car. And that was the evidence at the preliminary hearing, kind of random at somebody. And that sort of instability, I think that makes him a flight risk. I can't really, what's going on in his head. I don't know.
Well, Judge, it's ironic that
sort of action. And when he's facing this much time, and when you have that sort of random violence that is hard to explain, there's a stability issue there. And in my experience, that also leads to not showing up for court, fleeing the jurisdiction. We've had several of those. So I went over this in detail at the last hearing. I don't care to do it again, but I think we've had multiple hearings on this, and it's been overruled by a couple different judges. So I think we've covered that. But anyway, moving on to the motion to withdraw. Mr. Eaton, have you reviewed that?
No, sir.
No, sir. Okay. Well, we have a hearing on motions to withdraw so that parties have notice and a chance to be heard. The stated reasons that I was able to pull out of the motion, Mr. Hamey's saying he's unable to adequately represent you at this time. Anyway, anything you want to add to that, Mr. Hamey?
no, Judge.
Okay. What's your position on him wanting to withdraw as your attorney? I do have other attorneys that are very capable attorneys that can take over 2 or 3. That would be good. So I can get him appointed today and get him started on your case. I could, Mr. Marcinski has an open file policy. I'm sure he'd be willing to forward all of the discovery and try to move this along as fast as we could. But anyway, I'll let you speak. What's your position on your attorney's motion to withdraw?
Well, I mean, I would like to know who's representing me. I'd like to know a little bit about them, and you know, I mean, I just don't want just anybody representing me. I want it to be
Right. I wouldn't appoint anybody that's unqualified.
Right.
I think you'll like the guy I have in mind. But anyway, what's your position on Mr. Hamey's motion? If you would. My assistant's going to hand you a copy of the motion.
um, well, if I don't know if the trial's happening or not. This as scheduled.
This trial next week, I'm not going to put 3 of them on for prime. They got 2 that are going to go in front of it. So that would, that's going to get continued anyway. This case would be continued either way.
Yeah, I mean,
Mr. Marchinsky, have you read my letter and information I provided to you?
I did some reading this morning, Jess, but I'm not going to be able to offer the offer you're asking. I'm sorry.
All right. Well, while Mr. Eaton's collecting his thoughts, Mr. Marcinski, what's your position on the motion?
Judge, I typically, as a rule, don't take a position on attorney-client issues. Like I said last week, justice delayed is justice denied. The state is, for all intents and purposes, ready to go, but I certainly believe that Mr. Eaton is entitled to a zealous advocate, and if Mr. Hamey no longer feels he can provide that, I think he should be released.
Okay. And it looks like the other 2 cases are going. We got the Felina Lude that's been hanging around for a long time, and we've got the other off-grid aggravated indie celebrities case that is ready to go as well. So I kind of need an answer from you, Mr. Eaton. This is one of the reasons I made him file a motion and gave you some time because it looked like it caught you off guard last week when he surprised you with a motion to withdraw. Did he surprise you with that?
yes.
Okay, so it surprised me too. He wants off the case now. He says he no longer can adequately represent you, and I'm concerned about that representation to the court, of course. But I'm also concerned about you. I need to know if you want to if you don't want to say anything about it, that's fine. I'll just make a decision without. But I want to give you the opportunity to have some input on your attorney's motion to withdraw.
Sir, I'm not sure I know enough about the matter to have an opinion on it.
Well, you're the one whose freedom's at stake. So right there, you have enough. Any opinion? There's no wrong answer here.
I mean, I want a good attorney who can represent me, and I don't I guess I don't know what that looks like.
Okay.
So,
Well, the guy I have in mind is Houston Bales, and he's, I've seen nothing but good things from him. Very zealous advocate.
I mean,
Experienced, qualified to do your case.
if I take him, is that set in stone, or can I?
You don't get to decide. You can hire any attorney you want to. But if I'm appointing, I'm going from the list of people on my panel.
Right, I understand.
Okay.
If you appoint him, would I be able to fire him and hire somebody?
You don't hire and fire. That's not the right language. You can always ask the court, if you don't like him, if there's some reason, we'll take it up, much like we're taking it up today. If you want him off your case, you can always complain to the court, state your reasons. I'll have a hearing. I'll listen to the attorney. I'll listen to you. Here it's the opposite. Your attorney's wanting off. I'm listening to you. I listened to the attorney last week and read the motion today, heard from the prosecutor.
I can't make a decision on that either. I haven't even talked to this gentleman. He's going to be representing me. I haven't.
Well, you didn't speak with Mr. Hamey before I appointed him either. So that's how.
That's not true, Judge. I'm not sure why you would say that because I went and met with him and we talked extensively after the hearing last week.
No. Before I initially appointed you in the first place.
Yeah.
I don't know if you can hear us. He's wanting to talk with this attorney. He says, I don't get to talk to him before you appoint him. And you hadn't, correct me if I'm wrong, but you had never met Mr. Eaton before I appointed you. Is that correct?
Not before. I thought you were referring to since I filed a motion.
I wouldn't, no, I didn't say that. Anything further, Mr. Eaton?
I mean, I suppose not.
All right. Well, I think I'll just take Mr. Hamey at his word that he's unable to add it, given all that's transpired here in the last couple of weeks. I'll take him at his word, find that's a justification. Also, since the case is being continued over a month anyway, it should mitigate any delay. So I will grant the motion to withdraw. And I will appoint Houston Bales. So we need to call him, contact him today, get the appointment paperwork done today. Mr. Marcinski, if you could get I know you have an open file policy, so I'm not ordering you to do anything that you don't want to do, but insofar as you have the open file policy, get all of the discovery to Mr. Bales as quick as you can so we can facilitate, a speedier resolution to this matter as we can.
Judge, I'm sure we'll have everything to him by the end of the week.
Very good. All right, moving on to, so with that, I will need to continue this matter on the court's motion to jury trial. And for now, we'll set it to February 3rd at 9 a.m. Pre-trial will be January 26th at 9:30. All right, this hearing's concluded. Moving on to State v. Donaldson, 25 CR 200. Party state appearances, please.
I'm sorry, Your Honor. Larry Marcinski, County Attorney on behalf of the state.
Bailey Schmiedler appears for Michael Donaldson.
What's this?
So he needs a first appearance on
Oh. All right. Well, let me just take up, I guess there's another matter he's got rested on this week, and I'll take that up here in a second. Just on this case, though, the matter set for trial next week, 25 CR 200. Do you have a motion, Mr. Marcinski, or is there an agreed order?
Both, Your Honor. The state did initially intend on moving for a continuance, and after speaking to Ms. Schmiedler, which at that point Mr. Donaldson was not in custody, The state filed this quickly. This is a case that I filed meth charges immediately upon a field test as opposed to waiting for KBI lab testing. As of last week, as I was preparing for trial, the KBI lab testing has not come back. So the state did reach out to Ms. Schmiedler to see if she would object to a continuance. Again, that may have changed because at that point, Mr. Donaldson was not in custody. I advised her of my issue. She advised that since this was the state's first motion for continuance, and that she didn't object as long as it was clearly notated that the continuance would go against the state for speedy trial purposes. So Wednesday, I did file an agreed order that set those things forth. The state was requesting a continuance to the February 3rd date with the hopes that I could have my evidentiary testing back by then. So that's what we were at. And there was a motion or an order filed to that effect on Wednesday, but I'm not positive if it's actually gone through or not, sir.
All right. Ms. Schmiedler, any objection to the motion for continuance?
No, Your Honor. May I ask? I did not know Mr. Donaldson was in custody.
I didn't either.
I was out of the office last week, so I apologize for not being up to date. But is there a new case or was there a bond violation filed? I'm not seeing anything in my file.
There's nothing. I'll get into that in a second.
Okay.
But on this case, no objection to the continuance?
No, sir.
If you'll stick around, though.
Yes, sir.
Okay, stick around because I'm gonna go through it as I'm reading it.
Okay, sounds good.
Okay.
Okay.
All right. So I'll grant the state's motion for continuance of jury trial. That will be set over to February 3rd, 9 a.m. Jury trial. January 26th, 1:30 will be the pretrial conference. Okay. Also, Mr. Donaldson, I'm reviewing a probable cause finding by Judge DeJarnett. It's like over the weekend, probable cause was found by Judge DeJarnett for a criminal threat, intimidation of a witness of some kind, aggravated intimidation of a witness or victim, assault, and harassment by telephone. It's like probable cause was found by Judge DeJarnett of the criminal threat, intimidation of a witness, assault, and harassment by telephone. He set your bond at $25,000. You can post that cash or professional surety, which is a bondsman. There's a list of bondsmen there at the jail who can bond you out. Condition on your bond, you're not to have any contact with Coulter Kern or Katie Kern. And you're to have GPS monitoring supervised by court services. And I assume that would be exclusion zones wherever it is they live. All right. You have the right to have an attorney represent you. There's not a complaint to give you yet because you were just arrested over the weekend. But let's just go ahead and go through that. You have the right to hire your own attorney at any time. You can do that now or anytime you want. You also can apply for court-appointed attorney. Do you know what you want to do with regard to an attorney?
I'd like to keep Miss Schmeidler. Your Honor, I had a job that was supposed to start this week in Wichita.
Well, let's get into that in just a second.
Okay.
But so is there an application in that file for court-appointed attorney? Guys, I don't have, yeah, I have it right here, actually. Never mind. I assume, did you file an application in that case, sir?
No, sir. I haven't had a chance to do anything.
Ms. Schmiedler's case, the one she's on, did you file an application on that one?
Oh, yes, sir. Actually, I was just
Yes.
appointed her. Yes.
Yeah, I see it on September 30th. There's a financial affidavit filed.
And you were approved back then. Has your financial condition changed significantly since then?
It has not, if I remain incarcerated. If I'm allowed OR, I have a great job. I started,
All right.
start this week.
All right, very good. I will, Ms. Schmiedler, any objection to me appointing you on these new cases, or this new case, I should say?
No, Your Honor, I guess I just want to clarify. There was actually a new case, not just like charges from over the weekend. Mr. Marchinsky has filed a new case.
I
No, he
Okay.
has not filed a new case, but when and if it comes through and he
Gotcha. Okay. I see. Yes, I have no
That's-
objection when and if it comes through.
We're all here. It's over the holidays.
No, I totally understand. I was just trying to
I just
clarify.
want to start this ball rolling while I got you here,
Fair enough.
so everybody knows what's going. So, so if you will, this is sort of a, you know, if and when Larry Marcinski files it, I'll go ahead and approve, or you being signed onto this case as well. I typically would set this over to the next Thursday docket, which is December 30th. Are you sure you're having a docket then?
He said he is going to have a doctor tomorrow morning.
Tomorrow
I'm
morning?
going to be here Thursday.
Okay. Oh, he's doing it tomorrow morning.
We're having a very limited docket, Judge. I don't think there's any reason to put this on there unless unless Bailey wants it, but I don't know anything's going to happen between today and tomorrow. And tomorrow's was just a very short docket since we're not having one again until.
All right. I'll
Your
set
Honor,
it
may we
to
put it on the 15th?
15th? Sure.
Yes, please. I have a docket that day. I've got several cases.
January 15th then at, what time's your 10:30?
please. Yes.
I'll set it at 10:30. And again, you're not appointed yet officially, but it will happen if Mr. Marcinski files.
Gotcha.
Okay.
Thank you.
All right, very well. All right, you wanted to be heard on bond, sir?
Yes, sir. I'd like to ask court for forgiveness. When I did was stupid.
Well, first of all, your attorney's here,
Right,
and you don't need to talk about this. Is why it's better to have an attorney help you.
right.
If you're asking forgiveness, anything you say can be used against you. So
I understood.
I wouldn't talk about the merits of the case.
Could I request OR out so I can get to this job I'm supposed to start? And I've got 2 animals that, as far as I know, they're going hungry and without food and water out where I live. I'm out in the middle of nowhere.
All right.
I don't know that anybody has checked on those animals. My place is unlocked.
All right. Mr. Marcinski, were you able to hear that?
I could hear his statement, Your Honor. At this time, the state would be objected to any bond modification. I haven't even reviewed it at all. All I know is that it's alleged that there's person felonies. I think with person felonies alleged, 25,000 is an appropriate amount. I haven't even read the PC affidavit that you have, Judge. So
Your Honor, may I ask a question?
Sure.
What do I do about the 2 animals possibly starving?
Oh, I don't know about the animals.
All right.
I'm gonna leave the bond where it's at. You can bring it up again with Judge adjournment, but it looks appropriate from the information I have here. But I think it is more appropriate to leave it where it's at, considering what we have here. And also, once the attorneys could get their hands on it, they're able to advocate for a position a little different. But given everything that's at stake, I think I'm gonna leave it where it's at right now. All right. Hearing concluded.